Good morning, everybody. We're just going to give it a minute to allow all participants to join. For those of you who are just joining, we're just giving it a minute to allow all the participants to join us, and then we will begin the webinar. Just another moment here to see if anybody else is going to be joining us, and then we will get started. All right. Well, good morning, everybody, and thank you for joining us for the Wisconsin Institute for Law and Liberty's Preserving Democracy Project webinar. I'd like to begin by introducing our President and General Counsel, Rick Essenberg. Rick is going to be giving an overview of the project, and then I'm going to talk about some of the work that we're doing after that. There is a Q&A function at the bottom of your screen. We ask that if you have questions you would like us to answer, please use the Q&A function at the bottom. There will be time at the end of the presentation where we'd be happy to answer questions. Any questions that we don't get to, you can email me, Lucas Vebber, and I'd be happy to answer them afterwards as well. And my email will be on the final slide coming up. But without further ado, I'll turn it over to Rick Essenberg. Thank you.
Good morning. It's my distinct pleasure to speak at the introduction of our Preserving Democracy project. I wanted to say a few words about what the purpose of the project is, and then we'll allow Lucas to explain, and explain quite well, what it is that we've been doing and how this thing cashes itself out in practice. But we all know that we hear a lot these days about our democracy being in peril and what we need to do to save our democracy, with our democracy frequently being sort of the operative term. And I think that makes some sense. We have a democracy, but we have a democracy of a particular type. Now, I am not getting into the debate about whether or not we have a democracy or a republic. We, to some extent, have both. But the point that we're trying to make here is that our democracy, our American democracy, has certain features. And among those features are the rule of law and the separation of powers. Our democracy works in a particular way. And so it's certainly true that our democracy can be threatened when people play games with elections. That shouldn't happen. But once we have placed people in power, they have an institutional responsibility to act in a certain way which is consistent with the principles of our democracy and how the people express their will within it. And so if we look at our democracy, we see that there is this separation of powers. Separation of powers is both horizontal and vertical. We have separation of responsibilities between the federal government and the state governments. And we also have within each level of government, and we have this at the federal government in Washington, and we have it the state government in Madison, a division of responsibilities among the various branches. And it is a necessary condition of our democracy that these distinctions be respected. And it is the objective of our Preserving Democracy project to make sure that they are. And so, it's quite possible that we could have a democratic system in which we simply elected a benevolent dictator, a president who will rule over us and decide what the law will be and stand for election every once in a while. History tells us that, if we do adopt a system like that, that person will not long stand for election. That person will have a tendency to destroy the competition and remain in power. Our founders knew that. And so they didn't adopt that type of democracy. We could have a system where a tribunal of people ruled over us in much the same way as courts are often accused of doing. And our founders didn't adopt that type of system either. And so what we're about here is to preserve our democracy as it's been handed down to us. And that is why we are concerned with process. We are concerned that, for example, responses to pandemic be adopted in a way which is consistent with constitutional restraints and statutory dictates that have been adopted by the representatives of the people. We believe that this is as essential to preserving our democracy as worrying about elections, because our democracy does not end with election results. That just begins the process of governing. And so to further explain what we're doing here, it is my privilege to introduce my colleague Lucas Vebber, who Lucas is has assumed the day-to-day responsibility for this very important project. I can't think of a person who is better qualified and capable of handling that responsibility for us. So I will quit talking, and I will join the rest of you and enjoy listening to Lucas Vebber.
Thank you, Rick, and thank you for that introduction. And thank you again to everybody for attending today. As Rick said, my name is Lucas Vebber. As I am loading up my PowerPoint presentation here, let me just give a brief hello and introduce myself. I am a litigator here with the Wisconsin Institute for Law and Liberty. And as Rick said, I'm overseeing this project along with much of the good work that my colleagues are doing. You should be able now to see the PowerPoint that I've got loaded. Part of the work that we're doing here is enforcing the structural limitations on government. It's ensuring that government doesn't take away liberty, because government doesn't have the power to do that. Government doesn't have the power to restrict individual rights that are guaranteed. And it's about bringing those cases that have lasting impact. So to illustrate this, and perhaps the best way to show what the project is going to accomplish or wants to accomplish or has accomplished, is to talk about a few of our past wins, to talk about those cases that we have open right now, and then to talk about where we see this project going in the future over the next year, over the next 5 years. So some of our past wins, 2 regulatory wins at the state level that I want to just discuss, because again, they illustrate using process to enforce those structural limitations on government. The first and a very important win was a case called School Choice Wisconsin Action versus the Department of Public Instruction. This was a case that we won shortly before the COVID pandemic came to being. The state regulator of schools, the Department of Public Instruction, had determined bizarrely that only public schools could use virtual learning to meet the hours of instruction requirements that they have in state law. So if a choice school, which has the same hours of instruction requirement, attempted to use virtual learning one day, those hours didn't count. But public schools, they did allow them to count. That was just a very bizarre, as I said, bureaucratic holding. Part of a pattern that we've seen of unfriendly to the choice program here in Wisconsin. But we brought a lawsuit on behalf of School Choice Wisconsin Action, which is a trade association of choice schools, arguing that that was unlawful, that it was essentially unlawful legislating, that they were adopting an illegal policy by interpreting the same statute 2 different ways for 2 different people. And we won that case. The state didn't appeal, and then COVID hit about a month later. And those schools fortunately were able to use virtual learning. Now, for those of us with kids, maybe we're pretty sick of virtual learning these days, but it was very important at the time to allow those schools to continue educating children. Another case, similar legal argument, was Tigan versus WEC. This was a case where WEC, the Wisconsin Elections Commission, had issued a guidance document. The guidance document purported to allow individuals to do something that state law didn't allow them to do. To return their absentee ballots to a drop box, an unmanned drop box located in various locations. We argued that that state law doesn't allow it, and that WEC doesn't have the authority to override state law, and that they certainly don't have the authority to override state law via guidance document. This is something that we see time and time again from state and federal agencies, that they don't go through the proper process when they want to adopt a regulation and try to force people to act a certain way. That case actually went all the way up to the state Supreme Court, where again, we won, and the use of those drop boxes was found to be unlawful. But our work in this area hasn't been limited to just the state government. We also filed suit against OSHA when OSHA implemented a mandatory vaccine rule for certain employers of a certain size. We filed one of the very first actions against that rule. Ultimately, everybody who challenged the rule got consolidated nationwide. The US Supreme Court sided with us. This was a rule where our argument was that OSHA simply didn't have the authority. Congress never gave that federal agency the authority to do what they were trying to do. Another important enforcement of the structural limitations on government, and in this case, the federal bureaucracy. So that's kind of just to give you some flavor. Will has obviously had a number of wins. We've been very fortunate to be very successful over the years, but I just wanted to just give a sample of a couple of the wins that we've had recently. Turning towards current cases that fall under this project and the work that we're doing right now. So one of the first cases I want to talk about is Florek versus Neenah. This is a local government case. It's a First Amendment case. This is a case where a couple in Neenah had opposed a potential city action. In this case, it was a rezoning effort that the city was considering. They put out a yard sign in their front yard that said that they opposed it. The city sent them a letter demanding that they take the sign down, and they were going to face fines of up to $1,000 a day if they didn't take the sign down. Fortunately, they contacted us. We filed a lawsuit in federal court, and we sought an immediate permanent injunction and a temporary restraining order. Just a few weeks ago, the judge ruled and granted our preliminary injunction. So that case is still ongoing. It appears going to be going to file summary judgment motions later this year, but for now, the city is not allowed to enforce that ordinance, and these individuals, the Floreks, are free to express their free speech rights under the First Amendment. Two other cases that we have going on right now are Braun versus WEC. This is a case that involves a question of federal versus state authority. So there is a federal elections regulator essentially produces a voter registration form. It's called the National Mail Voter Registration Form. It's then made available on their website. The state of Wisconsin has very specific statutory requirements for voter registration forms in our own state law. WEC has produced a form that's compliant with Wisconsin law. It requires everything that you need to do to register to vote by mail. And that form is available. And yet WEC has also allowed people to register using this national form that the federal government produced, which doesn't contain or meet the same standards in Wisconsin law. So we filed this lawsuit arguing that Wisconsin law controls here, that the federal form doesn't meet the standards in Wisconsin and can't be used. Certainly, anybody who wants to register to vote can still use the Wisconsin form. That's available. It is ready to be used and is not being challenged in this action. But that case gets to the heart of really who's in charge when there's a state law that's very specific for registering to vote here in Wisconsin. Another case is Pellegrini versus WEC. This is a case that was related to a case we filed last year, and it challenges WEC's ability to delegate its authority to its staff. So again, getting to those structural limitations on government, who is it that determines who makes these decisions? Is it the legislature in the law, in statute, or is it the bureaucrats who've been appointed to enforce those laws? Can they just turn around and give that power to someone else? Now, our lawsuit obviously argues that they cannot, and that it is up to the legislature to make these decisions. The legislature has set up a complaint process. That process allows you to file election law complaints with the Wisconsin Election Commission. It requires the commission itself to resolve those complaints. What WEC has done, though, is that they've delegated authority to the staff to essentially answer those questions for them. Mr. Pellegrini had filed a complaint. His complaint was dismissed by staff. So he brought this challenge, arguing that what WEC has done here goes too far. It violates what their authority is as an agency of the state. They can't give their power away to their own staff. Another very important case that we have right now is another School Choice Wisconsin action case. We represent them as well as 2 schools in the choice program against the Department of Public Instruction. And this deals with what we refer to as a perfection rule in the choice program. So what DPI has done is they've gone out of their way to really impose some barriers within the choice program. It just makes it very difficult for schools to apply. So for example, DPI has required that when schools take an application for the program, they have to verify that applicant's residency. They have to verify where they live. But they take the position that everything has to match absolutely perfectly. So for example, if you live on North Main Street in North Prairie, you're allowed to abbreviate the North in North Main Street. But if you abbreviate the North in North Prairie, DPI takes the position that that doesn't match and that you can't get into the program. You have to correct that application. It's really a silly rule that they enforce. I mean, everybody certainly knows what these abbreviations mean. We also see it time and time again when somebody lives on a county highway. It might be referred to as, County Highway H, or it could be CTY H, or it could be, County Road H, maybe they write it as. If you wrote a letter to any of those addresses, they would all get to the exact same place. The post office can figure it out and they certainly understand. But DPI takes the position that if you don't write it perfectly and it doesn't match perfectly in your application, that you cannot enter the program. Our lawsuit challenges that. We have said that the way that they've enforced those policies is unlawful. It goes beyond their authority. It violates the structural limitations on government because they adopted those policies without going through the proper lawful process. And that really gets at the heart of the work that we're doing here with the Preserving Democracy Project. It's ensuring that if bureaucrats are going to implement something that is burdensome, like this type of rule and the other rules that we've discussed, that they do so in the light of day and that they do so subject to all of the transparency and oversight that is required by state law. We've seen this again beyond just the state level, at the federal level with Lewis versus Walsh. This is a challenge to a recent regulation from the Department of Labor relating to ESG, so environmental, social, and governance. These are, they essentially want to play politics with retirement accounts of Americans. So they want to allow individuals who previously just had to have your best interest as a retiree and what it could maximize your retirement account. Now they want to allow them to be able to factor in ESG factors. So things that go that don't have your best interest in mind and aren't about maximizing your retirement, but are instead something else. And the worry there, of course, is that it's putting Americans' retirement accounts at risk. For decades and decades, we've had one standard that we have followed, and this rule attempts to change that standard. And as I said, attempts to play politics with retirement accounts. Now, our argument, of course, is that they can't do that. That again, it violates that structural limitation on the Department of Labor as a federal agency, that they don't have the authority to do this. Congress never gave it to them, and some other concerns that we raised in the lawsuit. We are also looking, various other federal agencies are attempting similar things, and we're certainly looking at those right now, and stay tuned for potential more news in the not too distant future. Another federal case that we have right now is Britto versus ATF. ATF is a federal agency. It stands for Alcohol, Tobacco, and Firearms. It's a bureau of the Department of Justice. They adopted a rule banning what is called a pistol brace. This is an accessory that attaches to pistols that you can brace it against your forearm. We represent 3 decorated veterans who are firearm owners who own pistol braces. We have challenged this rule. Like our other challenges, this raises statutory concerns. We believe it violates the Federal Administrative Procedures Act, which again is that process that they have to follow to adopt rules. We also raise constitutional concerns here with the Second Amendment and the ability of a federal agency to regulate something that, in this case, something that the agency for the past decade has said is perfectly lawful and not regulated by federal law. And then overnight, they adopted a rule which purports to make millions of Americans into felons. Currently, we have a motion to for a preliminary injunction that's been fully briefed and is pending. That case is filed in Texas, federal court in Texas. We expect to hear a decision on that any day now. So the most recent current case that you may have seen this morning is Star News versus FBI. This is a federal FOIA administrative appeal. It's an action that we just filed. We represent a newspaper and reporters who made a FOIA request for the manifesto of the Nashville school shooter. The FBI has refused so far to turn that document over, despite it being of great public interest. The governor of Tennessee has called them in the legislature into a special session. They are attempting to legislate, ways that they can prevent this from ever happening again. Something that's very important as they take that work is to know why this happened in the first instance. And a big part of knowing why it happened is having that manifesto, having the writings of that individual who committed those heinous crimes. But the FBI hasn't released it. We represent a newspaper and 2 reporters who are attempting to get that so that they can write on it. And that administrative appeal was filed last night. So aside from just being a transparency issue, this is a First Amendment freedom of the press issue. It's important, a very important part of our democracy is the ability to hold government accountable. And you can't hold government accountable if you don't know what they're doing and you don't have ready access to the records of government. So we've been involved in a number of cases at the state level, and now getting involved at the federal level and enforcing FOIA is a big part of holding that government accountable. And I apologize that last bullet point there has an incomplete sentence, but ensuring ready access to records is vital to preserving our democracy is what that should read. So that's where we've been, and that's where we are right now in the cases that we're pushing and working towards. Going forward, we intend to really expand this work that we're doing. The project will continue to enforce the structural limitations on government power. We will hold government accountable at the local, state, and federal level. Wherever a bureaucrat is trying to take away the freedom of anyone, we will be there and we'll be interested in determining if we can do anything to help that person. These cases that we bring will involve government overreach. That's bureaucrats going against their lawful authority and regulations, or taking some enforcement action that they don't have the authority to take. Those are the types of cases that we're looking to bring. But more importantly, we seek cases that have a broad and lasting impact. Well, it's certainly important to win. One-off wins are very important, and individuals may need to fight government in a one-off situation. Those aren't the cases that we're trying to focus on. When we take a case, we're taking a case because we believe it can have a broader impact. It can establish some precedent, some rule of law that can be used going forward to hold government accountable and rein in the administrative state at the state and federal level. Will, of course, doesn't charge our clients. Where possible, we do seek our attorney fees when we're victorious, and we have been able to get those in some cases. But the bulk of our support comes from our generous donors who support our mission and the work we do, including many of you who are tuning in today. So I just want to say thank you for what you've been able to help us do over the years, and hopefully what you'll continue to support going forward. And this project, though, is not limited to just litigation. So we also have a public education component, which is key to the work that we're doing. So we have already produced the Citizen's Guide to the Administrative State. This is a guide for Wisconsin rulemaking, essentially, to understand how agency bureaucrats essentially write laws and where individuals can get involved in that process and how they can be a part of shaping those regulations. We've presented on that around the state, including, I believe, to a number of you who are tuning in today. So for those who have heard the presentation, I hope you enjoyed it. For those who haven't, we would love to come speak with you or a group or whatever we can do to get that out in front of you. We'd love to chat, so please reach out. We have a follow-up, which we're calling the Citizen's Guide to the First Amendment, which will be coming out soon to advise individuals of their rights under the First Amendment, to know what to look for, to know when it's time to contact an attorney, and to help issue spot some of the things that government is doing that is simply unlawful. And so, as I said, while our litigation efforts are vitally important and seek to enforce lasting change, part of enforcing that or getting that lasting change is to educate the public on these issues so that individuals everywhere can help hold government accountable and help do the work that we're doing on a day-to-day basis. So hopefully that gives you a good overview of where we've been, where we are, and where we want to go. I really do appreciate everybody hopping on the call today. I'm just going to leave this up for a split second before we get to any questions. This has my email address on there. Again, I am Lucas Vebber, one of the deputy counsels here at Will. You can email me anytime. Our phone number at Will is on there. It's very easy to remember. And I have my Twitter account there if anybody ever wants to follow me on there as well. So I am going to end the slideshow now and then take a look and see if we have any questions that did come in. All right. Yeah, we have one question that came in regarding the recent Supreme Court election. That election, this question says, the recent Supreme Court election directly threatens the separation of powers. How can Will help lessen that threat? Well, the first thing that we can do is that we're going to be here. We are boots on the ground. We're not going anywhere. Anybody who tries to unravel or undo the good work that we've done to enforce our separation of powers over the years, we will be doing everything we can to be involved in those actions and taking affirmative steps to uphold the law as it has been for the past decade and beyond. And so that's, I think, the simplest thing that we can do. But I would just say that, you know, a lot of the work we do is state court, a lot of the work we do is federal court. We will continue to push forward. We will continue to obtain new wins. We will continue to defend the wins that we've had in the past. And that is our plan on that. Another question that came in is, how do we coordinate with other national think tanks who litigate similarly to us? Think tanks in other states, there are litigation centers. So Will, as an organization, I believe is the largest state-based litigation center in the country. We have a very good relationship with our friends in other states, whether it's Goldwater in Arizona or some of the national groups, you know, Institute for Justice or Pacific Legal. Typically, we try to talk with them on, and if there's going to be a big case that's coming up, you know, we try to work together with them so that we can get them to support us either through amicus briefs or so that we can support them through an amicus brief and try to help each other and make sure that we're not duplicating efforts or wasting resources within kind of the freedom movement that we all work. And I think that's a really important question. And we need to always be making sure that we're all rowing in the right direction. I think today we've done a pretty good job of that, and I would like to see that continue. And if you want any updates on our project, you can sign up on our website. I see one of the questions here came in and it has a link to it. I'm just going to add that to the answered list. I think anybody can click on that link then if you're on the Q&A section. And if there are no more questions out there, I will turn it back over to Rick Essenberg. Yes.
Yeah, I just wanted to say something about you know, this issue of the last state Supreme Court election. Elections have consequences. We understand that. But one of the things that I always say when I talk to our friends on the left with respect to this question of the rule of law and the separation of powers, and this particularly came up when we were litigating over the extent of the governor's emergency powers during the COVID pandemic, is this is not a left and right issue. It is almost a scientific certainty that there will be no permanent victories in politics. And you may like the president today, you may like the governor today, you may like the majority of the state Supreme Court today, but there will be a time when you don't. And one of the important attributes of structural limitations in the power of government, separation of powers and the rule of law and the specification of the process by which decisions be made, is that they prevent one side from running over the other. And so, you know, let's use the governor's emergency powers, which were the issue in the Fabic case that we participated in the argument back in 2020. You know, Governor Evers wanted to assert that his emergency powers were unlimited, that he could declare emergencies in series and rule by decree during that period. Now, you could say that he was relatively modest. He simply imposed a mask mandate, but the claim he made as to what he has the power to do was extraordinary. And nobody on the left or the right should want to cede that much power to one person, even if that person was at one time in the past elected. And so the argument that we're going to make is that this isn't a left or right issue. This isn't about what particular policies that you want. It's about how those policies can be made. And can we all agree that that process by which those policies made is something that's very important and allows us to live our common lives together, because while we can't agree on particular outcomes, we can agree that this is the process by which those outcomes are to be reached.
Well said, Rick, and thank you for that. Seeing no other questions from anyone, I just want to say thank you again for attending our webinar today. If anybody does have a question that comes about the project, please feel free to reach out anytime. I'm always happy to talk about the work we're doing or answer anything about Will or where we're going. So thank you all for joining us today, and I hope you all have a wonderful rest of your week and a great weekend. Take care.